Good day, everyone. We're now going to discuss some of the possible questions that might come up on the subject of commercial law. Okay, again, disclaimer, this did not come from any other source. It just came from our own insight, our own opinion, and again, take it with a grain of salt. Let's begin. Tan was doing business under the name of Yon Mitori, a single proprietorship. He deposited 420,000 pesos in his Union Bank account drawn against the BPI check of one of his clients. He withdrew 400,000 pesos from his account from the former. However, Union Bank discovered that the BPI check was drawn from a closed account. Union Bank sent a letter to Tan demanding the return of the 420,000 he withdrew. Tan refused to return the said amount. Union Bank then debited the available balance reflected in Tan's account amounting to 34,000 pesos, and thereafter instituted a complaint for a sum of money for the remaining balance. The RTC ruled in favor of Union Bank. On appeal to the Court of Appeals, the lawyer of Tan filed a petition naming Yon Mitori as the sole petitioner, claiming that it has a separate and distinct personality from Tan. Rule on the petition. The petition should be denied because Yon Mitori has no separate juridical personality. The Supreme Court ruled that only natural and juridical persons or entities authorized by law may be parties in a civil action. A single proprietorship is not considered a separate juridical person under the Civil Code, based on the case of Yon Mitori International Industries versus Union Bank. What is the rule on ownership of corporations? What the Constitution requires is full and legal beneficial ownership of 60% of the outstanding capital stock, coupled with 60% of the voting rights, must rest in the hands of Filipino nationals. One Christmas morning, Colipano and her daughter were paying passengers in the jeepney operated by Sanico, which was driven by Castro. Colipano claimed she was made to sit on an empty beer case at the edge of the rear entrance or exit of the jeepney with her sleeping child on her lap. And at an uphill incline in the road to Natimanoan, Carmen, Cebu, the jeepney slid backwards because it did not have the power to reach the top. Colipano pushed both her feet against the stepboard to prevent herself and her child from being thrown out of the exit. But because the stepboard was wet, her left foot slipped and got crushed between the stepboard and a coconut tree, which the jeepney bumped, causing the jeepney to stop its backward movement. Colipano's leg was badly injured and was eventually amputated. Colipano filed a complaint for breach of contract of carriage and damages against Sanico and Castro. Should the complaint be given due course? The complaint should be given due course only on the part of Sanico and not on the part of Castro because Castro is not a party to the contract of carriage. The Supreme Court ruled that a complaint for breach of a contract of carriage is dismissible as against the employee who was driving the bus because the parties to the contract of carriage are only the passenger, the bus owner, and the operator. Is the doctrine of separate juridical personality absolute? No, it is not absolute. As a rule, an officer may not be held liable for the corporation's labor obligations unless he acted with evident malice and or bad faith in dismissing an employee, based on the case of Cymex Security Services versus Rivera. On or about April 22, 2002 in Melbourne, Australia, Siacol, a foreign company, solicited and received shipments of pieces of STC musical instruments from shipper Dominant Musical Instrument for transportation to and delivery at the Port of Manila. Complete and in good condition as evidenced by a bill of lading number 502645. Seacol then loaded the insured shipment on board MS Buckscrown for transportation to Melbourne, Australia, to Singapore. In Singapore, the shipment was transferred from MS Buckscrown to MS Doris Wolf for final transportation to the Port of Manila. The aforesaid shipment was insured with ICNA against all risk under its policy number MOPA 06310 in favor of the consignee San Miguel Foundation for the Performing Arts. Hereon, San Miguel. On May 12, 2002, MS Doris arrived and docked at Manila International Container Port, North Harbor, Manila. The container van was discharged from the vessel and was received by Unitrans, and upon stripping the contents thereof, it was found that 2 of the cartons containing the musical instruments were in bad order condition. Per Turnover Survey Report number 6, dated May 14, 2002. Unitrans then delivered the subject shipment to the consignee. After further inspection, it was found out that the 2 units of musical instruments were damaged and could no longer be used for their intended purpose. Hence, were declared a total loss. Is Unitrans liable for the damaged items? Yes, Unitrans is liable for the damaged items because, as a common carrier, it failed to exercise extraordinary vigilance over the goods it transported. Jurisprudence dictates that to overcome the presumption of negligence, the common carrier must establish by adequate proof that it exercised extraordinary diligence over the goods. It must do more than merely show that some other party could be responsible for the damage. Based on the case of Unitrans versus Insurance Company of North America. What are the requisites before the incontestability clause can be invoked? The insurance is a life insurance policy payable on the death of the insured. Second, it has been enforced during the lifetime of the insured for at least 2 years from the date of its last reinstatement. The period of 2 years may be shortened, but it cannot be extended by stipulation. Based on the case of Insular Life versus Co. What is the effect on the contract if the insured does not have any insurable interest over the property insured? The contract is unenforceable based on Section 18 of RA 10607. In a life insurance, who are those disqualified to be beneficiaries? Any person who is forbidden from receiving any donation under Article 739 of the Civil Code cannot be named beneficiary of a life insurance policy. These are those made between persons who are guilty of adultery or concubinage at the time of the donation, those made between persons found guilty of the same criminal offense in consideration thereof, those made to a public officer or his wife, descendants and ascendants by reason of his office. What kind of interest is not insurable? A mere contingent or expectant interest in anything, not founded on an actual right to the thing, nor upon any valid contract for it, is not insurable. Section 16 of RA 10607. What is the rule on suicide in life insurance? The insurer in a life insurance contract shall be liable in case of suicide only when it is committed after the policy has been enforced for a period of 2 years from the date of its issue or of its last reinstatement, unless the policy provides a shorter period, based on Section 183 of RA 10607. If the insured is insane when he committed suicide, will his life insurance still be compensable? Yes, that suicide committed in the state of insanity shall be compensable regardless of the date of commission, based on Section 183 of RA 10607. The incontestability clause apply in all types of insurance. True or false? False. It only applies in life insurance. What is the incontestability clause? After a policy of insurance made payable on the death of the insured shall have been in force during the lifetime of the insured for a period of 2 years from the date of its issue or of its last reinstatement, the insurer cannot prove that the policy is void ab initio or is rescindable by reason of the fraudulent concealment or a misrepresentation of the insured or his agent, based on Section 48 of RA 10607. What is the effect of the delivery of the insurance policy and the premium is not paid? The policy will lapse and be forfeited by its own terms. When is the insurer entitled to the payment of premiums? The insurer is entitled to the payment of premium as soon as the thing insured is exposed to the peril insured against, based on Section 77 of the Insurance Code. Define the cash and carry rule. Notwithstanding any agreement to the contrary, no policy or contract of insurance issued by an insurance company is valid and binding unless and until the premium has been paid. Section 77 of the Insurance Code. When is a person not entitled to a return of premiums? A person insured is not entitled to a return of premium if the policy is annulled, rescinded, or if a claim is denied by reason of fraud, based on Section 82 of the Insurance Code. What is the rule of suspension of payments? Based on Section 94 of the FRIA law, a verified petition for suspension of payments may be filed by an individual debtor who possesses sufficient property to cover all his debts, but foresees the impossibility of meeting them when they fall due. What are the effects of the issuance of orders suspending payments? First, the court may issue an order suspending any pending execution against the individual debtor. Second, no creditor shall sue or institute proceedings to collect his claim from the debtor from the time of the filing of the petition for suspension of payments and for as long as proceedings remain. Section 96 FRIA law. Where shall the stay or suspension order not apply? The stay or suspension order shall not apply First, to cases already pending in appeal in the Supreme Court as of commencement date, provided that any final and executory judgment arising from such appeal shall be referred to the court for appropriate action. Second, subject to the discretion of the court, to cases pending or filed at a specialized court or quasi-judicial agency which, upon determination by the court, is capable of resolving the claim more quickly, fairly, and efficiently than the court, provided that any final and executory judgment of such court or agency shall be referred to the court and shall be treated as a non-disputed claim. To the enforcement of claims against sureties and other persons solidarily liable with the debtor and third party or accommodation mortgagor, as well as issuers of letters of credit, except when the property subject of the third party or accommodation mortgage is necessary for the rehabilitation of the debtor, as determined by the court upon recommendation by the rehabilitation receiver. To any form of action of customers or clients of a securities market participant to recover or otherwise claim monies and securities entrusted to the latter in the ordinary course of the latter's business, as well as any action of such securities market participant or appropriate regulatory agency or self-regulatory organization to pay or settle such claims or liabilities. To the actions of a licensed broker or dealer to sell pledged securities of a debtor pursuant to a securities pledge or a margin agreement for the settlement of securities transactions in accordance with the provisions of the Securities Regulations Code and its implementing rules and regulations. Clearing and settlement of financial transactions through the facilities of a clearing agency or similar entities duly authorized, registered, and/or recognized by the appropriate regulatory agencies such as the Bangko Sentral ng Pilipinas and the SEC, as well as any form of actions of such agencies or entities to reimburse themselves for any transactions settled for the debtor. And last, any criminal action against the individual debtor or owner, partner, director, or officer of a debtor shall not be affected by any proceeding commenced under this Act, based on Section 18 of the FRIA Law. Discuss the rule on the cram-down power of the court. The court may confirm the rehabilitation plan despite the rejection by the creditors, provided that the circumstances required by law are present. What are the circumstances where the cram-down power of the court may apply? First, the rehabilitation plan complies with the requirements specified by law. Second, the rehabilitation receiver recommends the confirmation of the rehabilitation plan. Third, the shareholders, owners, or partners of the juridical debtor lose at least their controlling interest as a result of the rehabilitation plan. Fourth, the rehabilitation plan would likely to provide the objecting class of creditors with compensation which has a net present value greater than which they would have received if the debtor were under liquidation. What is the effect of a liquidation order? Upon issuance of the liquidation order, the juridical debtor shall be deemed dissolved and its corporate or juridical existence terminated. Second, legal title to and control of all assets of the debtor except those that may be exempt from execution shall be deemed vested in the liquidator or pending his election or appointment with the court. Third, all contracts of the debtor shall be deemed terminated and/or breached unless the liquidator within 90 days from the date of his assumption of office declares otherwise and the contracting parties agrees. Last, stay all actions, provided that no separate action for the collection of all unsecured items shall be allowed, and such actions already pending will be transferred to the liquidator for him to accept and settle or contest. And last, no foreclosure proceeding shall be allowed for a period of 180 days, based on Section 113 of the FRIA Law. What are the rights of a secured creditor? The liquidation order shall not affect the right of a secured creditor to enforce his lien in accordance with applicable contract or law. A secured creditor may, first, waive his right under the security or lien, prove his claim in the liquidation proceeding, and share in the distribution of the assets of the debtor, or, second, maintain his rights under his security or lien, based on Section 114 of the FRIA Law. What is the rule on the right of set-off? If the debtor and the creditor are mutually debtor and creditor of each other, one debt shall be set off against the other, and only the balance, if any, shall be allowed in the liquidation proceedings, based on Section 124 of the FRIA Law. What is the rule on the sale of assets in liquidation? General rule, the liquidator may sell the unencumbered assets of the debtor and convert the same into money through public auction, except a private sale may be allowed with the approval of the court if, first, the goods to be sold are of a perishable nature, or are liable to quickly deteriorate in value, or are disproportionately expensive to keep or maintain, and second, The private sale is for the best interests of the debtor and his creditors, based on Section 131 of the FRIA law. WWF arranged with spouses Pobre, owner of a minibus, for the transportation of 33 members from Manila to Lower Antipolo and back. Kane, the driver, was unfamiliar with the area, took a detour. The road was slippery because it was raining, causing the bus, which was running at a speed of 50 kilometers per hour, to skid to the left road shoulder. The bus turned over and landed on its left side. Several passengers were injured. The trial court held spouses Pobre, the common carrier, and Kane, the driver, solidarily liable for the injuries suffered by the passengers. Spouses Pobre interposes as a defense that they observed due diligence in the selection and supervision of the employee. Are they correct? No, the spouses Pobre are not correct in interposing their defense that they observed due diligence in the selection and supervision of their employee, because they are bound to exercise extraordinary diligence for the safe transportation of the passengers to their destination. As Article 1759 of the Civil Code provides, common carriers are liable for the death of or injuries to passengers through the negligence or willful acts of the former's employees, although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carriers. This liability of the common carrier does not cease upon proof that they exercised all the diligence of a good father of a family in the selection and supervision of their employees. Based on the case of spouses Fabre versus Court of Appeals. The respondents who were employed as security guards by McLowan Security were not paid their overtime pay, rest day, SIL pay, and 13th month pay. The respondents thereafter filed a case against the petitioner corporation. Captain Delisay, the operations manager of petitioner McLowan, told the respondents that they would not be given a duty assignment unless they withdrew their complaint before the labor arbiter. The respondents then amended their complaint before the labor arbiter to include illegal dismissal. In their defense, petitioners McLowan and its president and chairman Pinuno maintained that they did not illegally dismiss the respondents and claimed that they are still included in the role of security guards. Should Pinuno be held solidarily liable with petitioner McLowan for respondents' monetary awards? No, Pinuno should not be held solidarily liable with petitioner McLowan for respondents' monetary awards because he has a separate and distinct personality from the corporation. The court has repeatedly emphasized that the piercing of the veil of corporate fiction is frowned upon and can only be done if it has been clearly established that the separate and distinct personality of the corporation is used to justify a wrong, protect fraud, perpetuate a deception. Pinuno is merely one of the officers of McLowan, and to single him out and require him to personally answer for the responsibilities and liabilities of McLowan are without basis. To disregard the separate juridical personality of a corporation, the wrongdoing must be established clearly and convincingly. It cannot be presumed, based on the case of Cymex Security versus Magdaleno Rivera. What is the trust fund doctrine? The trust fund doctrine provides that subscriptions to the capital stock of a corporation constitute a fund to which the creditors have a right to look for satisfaction of their claims. In a sense, they have to be unimpaired for the protection of the creditors. This covers the entire consideration received for the issuance of no par value shares or the aggregate amount for the par value shares issued by the corporation. The Board of Chemicorp, acting on a standing authority of the stockholders to amend the bylaws, amended its bylaws so as to disqualify any of its stockholders who is also a stockholder and director of a competitor from being elected to its board. Yobo, a stockholder holding sufficient assets to assure him a seat in the board, filed a petition with the SEC for a declaration of nullity of the amended bylaws. He alleged, among other things, that as a stockholder he has acquired rights inherent in stock ownership, such as the right to vote and to be voted upon in the election of directors. Is the stockholder's petition tenable? No, the petition of the stockholder is not tenable because a corporation is authorized to prescribe the qualifications of its directors. Jurisprudence dictates that a provision in its bylaws of the corporation that no person shall qualify to be eligible for nomination for elections to the board of directors if he is engaged in any business which competes with the corporation is valid. A director stands in a competition from being elected to the board of directors is a reasonable exercise of corporate authority. Sound principles of corporate management counsel against sharing sensitive information with a director whose fiduciary duty to loyalty may well require that he discloses this information to a competitive rival. In the case of Bard, the petition of Yobo is not tenable because he has no vested right to be elected as the director. When a person buys stock in a corporation, he does so with the knowledge that its affairs are dominated by a majority of the stockholders. Such an amendment made in the bylaws is valid. How is ownership of a trademark acquired? Under the Intellectual Property Code, the ownership of a trademark is acquired by its registration, while subsequent use of the mark and proofs thereof are required to prevent the removal or cancellation of a registered mark or the refusal of a pending application under Intellectual Property Code. This should not be taken to mean that actual use and proofs thereof are necessary before one can own the mark or exercise the rights of a trademark owner. How is ownership of a trade name acquired? Ownership of a trade name may be acquired not necessarily by registration, but by adoption and use in trade or commerce. Based on the case of Zuneca Pharmaceuticals versus Natrapan. What are the tests to determine confusing similarity? Dominancy test, holistic test, idem sonance test. What is the dominancy test? The dominancy test considers the similarity of the prevalent dominant features of the competing trademarks that might cause confusion, mistake, and deception in the mind of the purchasing public. More consideration is given on the oral and visual impressions created by the marks on the buyer of the goods, giving little weight to the factors like processes, quality, sales outlets, and market segments. What is the holistic test? The holistic test considers the entirety of the marks as applied to the products, including the labels and packaging, in determining the confusing similarity. The focus is not only the predominant words, but also the features appearing on the labels. What is the idem sonance test? The test used to determine confusing similarity of two marks based on similarity of sounds or pronunciations, based on the case of Dermaline versus Myra. What are the rights conferred by registration? First, exclusive right to prevent all third parties not having the owner's consent from using in the course of trade identical or similar signs or containers for goods or services which are identical or similar to those in respect of which the trademark is registered, where such use would result to a likelihood of confusion. Second, exclusive right to use the mark and sue for infringement. Based on Section 147 of the Intellectual Property Code. What is the most essential element of trademark infringement? The infringing mark is likely to cause confusion. What is unfair competition? The passing off or attempting to pass off upon the public of the goods or business of one person as the goods or businesses of another, with the end and probable effect of deceiving the public that the goods are those of his competitor. Intent to deceive must be established. For letters, who owns the copyright? In respect of letters, the copyright shall belong to the writers subject to the provisions of Article 723 of the Civil Code. Discuss the four-factor test to determine fair use. In determining whether the use made of a work in any particular case is fair use, the factors to be considered shall include, first, the purpose and character of the use. Second, the nature of the copyright work. Third, the amount and substantiability of the portions used in relation to the copyrighted work as a whole. And last, the effect of the use upon the potential market for or value of the copyrighted work.